The first respondent had asked us to do so, and we had no reason not to believe that she was acting in good faith, only for us to realize we were deceived.
Is the story believable? The legal teams disagree.
We are beginning to see clearly that fallacy, at best, is something that cannot stand cross-examination.
The evidence of Dr. Pesa White made it abundantly clear that the chairperson of the Electoral Commission on that very day acted in bad faith.
That's coming up on Top Story, made possible by Vodafone. The future is exciting. Ready, Gassim, the nation builder, and Belacqua Mineral Water. And tonight, day 8 of the election 2020 petition hearing ended with lawyers for John Dramani Mahama raising concerns about what they believe was harassment of their witness by the Supreme Court's justices. Dr. Michael Pesa White, who is Mr. Mahama's second witness, was cross-examined by the lawyers for the Electoral Commission and President Akufo-Addo's lawyers as well. The examination centered mainly on Dr. White's allegation that the EC chairperson deceived him into leaving the EC strong room to pave way for a declaration of results based on problematic figures. Listen to excerpts of the cross-examination today.
Stated, we had been asked by the Electoral Commissioner when we brought our concerns to her attention to go and have a deliberation with the petitioner. If she had allowed us to come back and she was still not convinced, we would have duly indicated those reasons there and allowed the process to continue. As it were, the process was truncated.
I have put it to you that you were not instructed by the chairperson of the first respondent to leave the room.
My lords, we were instructed by the first respondent. I had no reason whatsoever to just lie or deceive these honorable courts if that was not the case. And as I had indicated, our living there was not in secret. We openly told almost everybody who was there that based on our discussions with the first respondent, this is what the outcome is, and that we were going to be back. The reason for which we left everything we had at the place.
I am putting it to you that what you have just stated is false. And I'm further putting it to you that if it were true,
I maintain that we had no reason for leaving the place. Indeed,
I am.
Yes, she did instructed us to leave. And my lords, on the Saturday after the declaration, I believe an official of the EC had said in public that he had seen Mr. Ruju Metonunu gone to the Electoral Commission chairperson whilst we were there. Of course, this official may not be privy to what they discussed, but I can say and maintain that it is on the basis of her instruction that we exited the place.
You see, on that day, you never spoke with the chair of the EC, did you? Yourself, you personally, never spoke with her.
My lords, we were there working as a team.
Please answer the question. I'm saying you.
I, as an individual.
Yes. You didn't speak with her.
I did not speak to the EC chairperson personally.
Thank you. Thank you.
So, excerpts of what transpired earlier during cross-examination at the Supreme Court. Joseph Akableza, man, he sat through the entire proceedings. He joins me in studio at this point with more from what happened at the Supreme Court. So, Joseph, Dr. White explained further that he was deceived. How does he explain this happened?
It was in response to a point that had been suggested to him that he was telling lies about this particular claim of being told by the EC chairperson to go over to confer with his presidential candidates, he responded that they had the option of walking away. They would have walked away long ago, and that it was the case of trusting the EC chairperson and going over to confer with their candidate because they thought it was in the interest of all parties related to the election that consultation takes place.
If walking away was an option for us at any given point in time, we probably would have done that long ago. We had never at any point in time imagined walking away, and we never walked away. We only exercised the option of going to see the petitioner because the first respondent had asked us to do so, and we had no reason not to believe that she was acting in good faith, only for us to realize we were deceived into getting out of the place. Besides, the reason why we believe strongly that we were deceived was originally the announcement of the election results was scheduled to take place at the International Conference Center. We were all told, everybody was aware. We were all prepared for it. Less than 10 minutes after we left the place, as I was told later by others who were in the room, the chairperson, together with the officials of the EC, came to call them upstairs and hurriedly announced the results. This, for me, indicates that there was a deliberate decision to deceive us.
Melting away or walking away by you two, you and Rojo Metonunu, was in dereliction of your duties to the petitioner.
My lords, we never walked away.
As a result of you being in dereliction of your duty, you then concocted this story and fed it to the petitioner, leading to the filing of this ill-fated action.
My lords, if this was ever a concocted story, we would not have left our laptops and our working tools in the EC's premises in the strong room. If this was a concocted story, we would have left in our individual cars. If this was a concocted story, we had no basis telling everybody else in the strong room what the deliberations between us and the returning officer was and why we decided to do what we were doing. Besides, some of the agents, after telling them that the chairperson of the EC had asked us to go consult with the petitioner and come back, had told us that, oh, we hope you come back in time so that we can complete the process. So there was no reason why we would at any point in time on our own walk out of the place, my lords.
Well, so Joseph, the EC's lawyer also had some concern about the fact that 12 out of the 16 regional results were certified by Mr. Mahama's agents, despite the concerns. What did Dr. White have to say about that?
He says the fact that some were certified and even the outstanding ones, 3 of them were won by the NDC presidential candidate. He says the fact that they didn't certify those ones indicates that they were just not in the place to ensure that their candidate wins, but they were there to check and ensure that the right figures go through the system.
My lord, the 4 regions that we did not sign, the reason was not because our regional reps did not sign.
Oh, please answer my question. When you make life difficult for me, answer the question. I'm saying that the 4 regions that your regional representatives did not sign, they also did not indicate the reason for their refusal to sign on the forms as required by the CEI 127. Answer the question.
Yes, my lord.
Good. Are you aware that out of those 4 regions that your representatives in the regions did not sign or indicate their refusal, the petitioner won 3 of those regions?
My lord, that is precisely the point. If our interest was just in winning...
Mr. You see, we've advised you, when you answer the question, you can add whatever you want to add.
Yes, my lord.
Explanation.
Yes, the petitioner had won. But we were not just interested in the winning, but also the votes and whether they truly represent and reflect the wishes and desires of the people. And we have noticed irregularities that we thought needs to be rectified. If we were there only to see forms that the petitioner was winning, I believe that we would have signed. But to the extent that, yes, the petitioner won those regions, but we did not sign and had raised issues, it's a clear indication that we actually were making sure that the writing is done according to law.
According to the law, raising issues must be on the Form 12s. Did you indicate any reason on any of the Form 12s?
My lords, we did not, because we never got to the point where an opportunity to indicate reasons on the form was provided.
Well, so Joseph, questions were fired from all angles, including the justices of the Supreme Court as well, that led to a claim of harassment. Walk us through that.
It was specifically an interaction between Justice Emefa Apawu and the witness, at which point Mr. Chikata, who leads Mr. Mohammed's legal team, came in. The point the justice had made was that by abandoning the work that they were assigned to do at the strong room, it appears they did not help the cause of their candidates. But Dr. White disagreed, and at that point, Mr. Chikata came in.
Would it be right for me to say that by taking contrary instructions from the chairperson of the first respondent, granted what you are saying is true, you did not help the cause of the petitioner who sent you there?
My lord, I don't believe that is true. We're working in furtherance of making sure that the results that ultimately gets announced by the first respondent reflect and represents the will of the people. And if she asking us to consult with the petitioner is part of how we could get there, we were happy to do it.
But then, seriously speaking, you did not take your training seriously. No, please.
It's not an appropriate question.
I want to be clear. You've gone to do a particular job. Then instead of doing the particular job that sent you there, you take instructions from somebody else. Then you leave your job. You see, that's what I want to find out. Then you did not help the petitioner.
My lord, with respect, his lordship is entitled to his opinion about what the petitioner did. In terms of factual evidence about what he did and the reasons that he has answered the question. So I don't think he can be harassed with these opinions.
Please, I take deference to that. I am not harassing the witness. It's not my duty to harass him. Well, I know that he has been sent by the petitioner to do a job for him. Then somebody tells you, oh, go to the petitioner and consult him. If the petitioner could do the work, he himself would have been there. That's what I want to find out. How am I harassing him?
Well, you're harassing him respectfully because the petitioner has indicated that it wasn't just somebody told them that go and talk to the petitioner. The petitioner has indicated that the returning officer...
The witness or the petitioner?
The witness. Thank you for the correction. The chairperson, not just anybody, was the person with whom his colleague had the conversation. And on the basis of that, they were sent to talk with the petitioner. And he has given every account. So if repeatedly an opinion is being put to him, that is harassment of the witness, and that's not allowed.
So that's the interaction between Justice Emefa Apawu and lead counsel for John Mahama, Chachu Chikata, when a question was posed to Dr. Pesa White, which Mr. Chikata raised concerns about. But of course, there were reactions to this from both sides after the proceedings today. Joseph, let's start first with the petitioner's team.
They were satisfied. They make the point that as far as they are concerned, Dr. Pesa White testified in a manner that advanced the petition.
I am pretty sure there was nothing unclear about the evidence that he gave. Judges are allowed to ask questions for clarification. What they are not allowed to do in terms of the law and ethics of judging is to descend into the arena of conflict. Now, as to whether they descended into the arena of conflict, I will leave that to you to judge. He did a good job of standing up, okay, as far as the issues that he was called upon to address are concerned. He was very credible. He was eloquent. And you heard the judges saying that he should stop lecturing. The former president is well, carrying on, the business of being the leader of the NDC. The former president is not required to be in court on a daily basis in order for his case to be heard. Otherwise, if that were the case, I'm sure the judges would have been asking where he is. Since they haven't asked, it's in order.
Doc, you've put in a request to inspect some documents. Earlier, I had seen a process that was directed at the Electoral Commission.
Right.
If you could explain how this is different from that one. And secondly, looking through the list of the documents, are those not documents that are supposed to be in the custody of the petitioner through his agents? And I also recall that this issue came up in the 2012-2013 petition as well.
Yeah, that is so. You will recall that we filed a notice to inspect the documents. The notice was duly served on the respondents, and the first respondent in particular has custody of all those documents. And by the way, this is to inspect the originals. It's not about us not having the documents. We want to authenticate what was provided to us and what has been put on the website of the Electoral Commission, and that motion will be heard, tomorrow. So I wouldn't want to take up some time on that one.
So that's Dr. Dominic Ayine. Hopefully, once the phone lines are cleared, we'll get him together with the NPP's legal team as well. But before that, Joseph, the President Akufo-Addo's team also had some reactions.
Yes, Kojo Nkrumah, who speaks for the legal team, insists that as far as they are concerned, yet again, their side of the story was advanced in the sense that here was a witness who was telling a story that, in simple terms, cannot be believed.
The bench has room to ask questions for clarification. And you hear the learned justices always say that we want to understand this one clearly. So to create an impression that when they ask you questions, they are harassing you, is part of the NDC strategy to begin to poison the minds of the general public against the bench. Because they can begin to see from the questions and the answers that they are giving, the gaps that are showing up in their case. Remember, they have already said that they think that this court is not a balanced panel. They have already been arguing that they have not been treated fairly and that some of the decisions don't make sense. Mareta Briopon. And today, they are furthering that by trying to poison the public by saying that they are being harassed. The bench has the right to ask questions. We believe that when our witnesses get into the box, they may even be asked questions. Nothing wrong with that. Now, this Form 13, which Mr. Kwesa White, under oath, claimed did not have room to state reasons for non-signing, is on page 62 of CI 127.
That's Kojo Nkrumah, a member of the legal team of President Akufo-Addo. Thank you, Joseph. Let's now bring in Dr. Dominic Akurutinga Ayine. He's a member of the legal team for the petitioner, John Dramani Mahama. Thank you very much for your time here on Newsnight. First off, second witness cleared. Dr. Kwesa White made your team happy?
Yes, he did make our team happy. He was very, credible. He was very clear. And certainly, made it abundantly clear what took place on the 9th of December. That made it impossible for them to be there at the point in time that the so-called Form 13 was completed and signed by the other agents. Now, Emefa, I want to correct a misimpression that is, that Kojo Nkrumah created in the clip that you just played, or I don't know whether it was, he was live on your program.
And that was after the proceedings and when he addressed the media as well.
Dr. Kwesa White never said anywhere that Form 13 does not provide a place for signing, or for, lodging a complaint if you do not agree with the results. Okay? What he said was that even though the original, summary sheets, that is, Form 12, contains a portion relating to complaints and, the signatures of agents that relates to regional, representatives or regional agents and not the national agents. So when those forms were transmitted to the head office, they could not have, inserted the complaints there because the complaints were supposed to be filed at the regional level. Okay? That is well apart from saying that the Form 13 does not contain a portion for lodging a complaint. So Kojo Oppong Nkrumah is obviously seeking to mislead the Ghanaian public with respect to the evidence that was given today.
Well, there are a lot of issues that comes up when you raise the issue about your witness being credible. Of course, the NPP side also raised it. But before then, once you're talking about Mr. Oppong Nkrumah's address to the media, for instance, they are of the view that your side deliberately want to poison the minds of the public against the judges. Is that what you're seeking to do?
How can we as seasoned lawyers seek to poison the minds of the public against the judges? Emefa, you watched, I believe you must have watched proceedings, and you have the clips. The Ghanaian public are also watching the proceedings. Okay? Now, when Mr. Chikata stood on his feet and protested that, Justice Emefa Apawu was harassing his client, was harassing the witness, okay? He did not say so out of, just wanting to talk back to the judge. He said so in protestation against what the judge was doing. Okay? The Ghanaian public watched it. And when Mr. Chikata insisted that the witness was being harassed, the honorable judge did the honorable thing by backing down and saying thank you. We all watched that.
But also insisted that he was not harassing and that it's not in his place to do so.
Well, it is any objective bystander, should make up their mind whether or not the judge was actually harassing the witness, because and that's why in our interview conversation with you, I said I did not want to go into the merits.
Okay? Of course,
because that is not something that is allowed. But we all watched the drama in court today, okay? And the line of questioning, okay, the interventionist manner in which this was taking place, did not augur well for judicial neutrality.
But of course, after the proceedings, for instance, in your address to the media, the thought about you mentioning that it appears that the justices had descended into the arena of conflicts, for instance, and then also previously you were asking.
I did not say that they had descended into the arena of conflict. All right. I said as to whether or not they descended into the arena of conflict, I was leaving it to the judgment of the Ghanaian public. There was no categorical statement on my part that the judges descended into the arena of conflict. Okay, so for instance, if a lawyer is conducting his cross-examination, okay, the lawyer for the first respondent is conducting his cross-examination. He tenders a document, okay, and the witness's lawyer says no. This document, he gives a document to the witness, all right, and seeks to cross-examine the witness on the document. And then the witness's lawyer says no. All right? He cannot be cross-examined on that document because it is not coming from him, and the document has yet to be tendered in evidence. Okay? And that objection is sustained by the court, and the document is taken back, and the lawyer backs down from cross-examining on that document. Then the bench, okay, one of the justices takes that same document, gives it to the witness and says that, she wants to ask questions pertaining to the same document that the bench, in respect of which an objection was upheld.
But if that particular document, for instance, was in the bosom of the court already, didn't the justices have any right to bring it up? They couldn't?
Please, you are talking with a lawyer. The fact that it is in the bosom of the court doesn't mean that you can examine the witness on it. The witness
that's why I was
not the
only
one who
asking.
tendered the document.
I'm only
And
asking.
that
I'm not a
document,
lawyer.
please.
I know that. Mm-hmm.
Yeah, no, please. So that document was not tendered through the witness.
Okay.
If it had been allowed to be tendered through the witness, then you can cross-examine him on that. But to come through the back door and give it to him and ask him questions on it, is unfair because the document came from the first respondent. And tomorrow, at any point in time that the first respondent's witness is in the dock, she will have to answer questions on that document, not Mr. Kwesa White. So why was there a kind of a attempt to get Mr. Kwesa White to speak to the content of that document?
Okay.
By all means.
But quick clarity, Dr. Ayine. I know we don't want to go into the merit of the case, but I'm just curious. If the EC chairperson instructed Mr. Metal Nunu to consult the petitioner, and then he also told Dr. White about it, why didn't we have Mr. Nunu rather testifying than Dr. Kwesa White today?
Why I don't know what a minute why the fuss is why the fuss about who was first communicated to. I don't think is that material at all. All right, if Mr. Nunu had come to say I was the one that the EC chair instructed, and then she said or her lawyer said I put it to you that the chairperson of the EC didn't talk to you, how would that have changed the story?
Because the concern is that he was, giving second-hand information. So
we're
just wondering.
There were two agents of the petitioner in the strong room. The fact that she did not communicate directly with Kwesa White doesn't mean that what he's saying is not credible. Because you see, once Roger Metrununu talked with him, and there is a video of Roger Metrununu granting an interview and narrating what exactly happened. That is not different from what Dr. Kwesa White told the court this morning. So I don't know why, instead of us focusing on the substance of what he said, we are focusing on whether or not there was any instruction at all given that they should go to, and meet with the petitioner. In any case,
because the public is wondering how the NDC from the very onset had raised concerns about adjournment, and then they would take instructions from here, and that was the concern.
Let us focus on the more serious matters.
Okay.
This is an independent constitutional body. They are not working at the behest of any party. So how come that when that day they were about to announce the results as collated, they never made an effort to get the NDC, to get its agents to be in the room for everything to be done properly? Why didn't they do so?
Okay. Well, Dr. Ayine, in wrapping up, you've mentioned that the witness made you happy, but did the entire proceedings make you happy as well?
I don't think I want to answer that question.
Okay. I respect that, Dr. Ayine. I'm grateful for your time. He's a member of the legal team of the NDC, the petitioner, I should say. And we've been speaking to him about proceedings today. And the second witness on their side has been cleared. They've also filed some application today. We've been talking about it earlier as well. Sincere apologies to Nanajwa Adubia Sante. She's a member of the NPP legal team. We were supposed to speak to her as well, but it appears that I have a technical challenge with my phone lines. But as and when we're able to raise her, we'll speak to her on Newsnight. That's it for Top Story, brought to you by Vodafone. The future is exciting already. Gasem, the nation builder. Bell Aqua, mineral water. Newsnight starts now.
55, 78, 58, 78. Hey, Charlie. My network is really killing me. I have to pay my uncle's workers via mobile money, but the charges alone, it's about 380 cedis.
Charges alone just to send money? That's $10 of cement already, my guy.
Listen, bro, you can save